Welcome, welcome. Thank you. Thank you for joining. Still, we advocate Ahava Learning very first empowerment series. I am so grateful that you've chosen to spend your day with us. I'd like to share um, some updates with you all before we get started. If you would allow me a time to change my screen. Here we go. Okay, let's go ahead and get started. So here we have a Howard Learning Empowerment Series. Still we advocate. My name is Renisha Parrish. I am a certified special education teacher, diagnostician, ESL teacher, administrator. Welcome. Thank you. Thank you for joining. Pardon me. Uh, I have functioned in several roles in public and private charter schools. And so I think that kind of sets me apart from most advocates. And what I'd like to share with you today are um, some of the amazing things that we have to share with you all. So to start off, I keep messing up. Okay. So to start off, I wanted to make sure that I specify my qualifications and what makes Ahava Learning so unique and different from most advocacy companies. Our advocates are certified. In education, we believe that healing, justice, and love are in action. And so, with that, with Ahava, we believe in advocating art. We're looking for, we're looking to make a difference. Ahava Learning initiative is to transform the educational and justice experience of youth who may be neurodivergent. It's founded and led by former educators and advocates. As I mentioned, Ahava provides early intervention, educational advocacy, parent training, and community advocacy along with it. We believe that healing is possible, and that's what we hope to promote through love, justice, in action. We have helped several people create individualized support programs, cultural responsive engagement in their IEPs. Oftentimes, IEPs miss that component. However, it is a part of the IDEA foundation. So it's something that we definitely want to make sure we're including. AHAVA is served for families from birth through adolescence. We help them navigate through the special ed system by accessing appropriate services, making sure uh, your information is documented appropriately in the IEP. So those are things that we are willing to do to help you heal and go through. There's a discipline rate and referrals. We know that it begins with inadequate educational interventions. A lot of times we have high referral rates in minority communities, males in particular, due to some of their behaviors. And so those inadequate qualities, sometimes there could be a lack of understanding and language skills, pragmatic skills, and other neurodiversity issues, such as sensory issues, could sometimes be an issue that would prohibit a kid from accessing their curriculum. So, as advocates, we ask that you trust the process. I'm sorry, my graphic is cut out, but we do look for a transformative and measurable impact. We offer file reviews to look over your IEPs. Again, as an advocate who is certified, I would be able to help you identify the areas in your IEP that might be weak or leave you open to some injustices. So that's part of our advocacy program. Next, we'll like to talk about due process. Now, I'm kind of putting the cart before the horse. We're going to go back and do a high level sped overview, but for right now, I want to go ahead and just get to the meat of the potatoes. The reason why you're here today, it is to learn about due process, how to advocate for your kid. And if you already know how to advocate, what do you do when the school still refuses to implement the IEP appropriately? Or if the IEP is implemented, your child is still failing. What can you do? What are your rights as a parent? Well, we do have the due process. Due process is offered to parents. It helps protect family rights. Uh, you can have an informal meeting, but I don't encourage families to take advantage of informal meetings unless it's a personality issue type deal. Otherwise, that you want to have everything documented in an IEP meeting. If you're in Texas, we call those ARD meetings. And anytime the school refuses a service or to consider a service, they should offer they should document it in the prior written notice and offer you a reason or justification why they're doing that. And we'll talk more about that as we go through the due process steps. So we have complaints that are not resolved, then there's another step to take. Your first step is always to try to settle it in the ARD committee with your local school, the district. Sometimes the district attorneys will get involved, but that's going to be your first step. If it's still not resolved, then you can always ask for a mediator from the state. That is an option as well. But the last resort or tool would be to go ahead and file that official due process complaint escalating to a hearing. But it will help ensure that your students' rights are legally enforced. So here's what happened after filling out a TEA special ed complaint, right? You write the complaint. There are forms that you can download. And again, I'm giving information specific for Texas, but it's the same for your state. If you are in a state that's not Texas, if you'll drop down in the comments and let me know where you're joining from, I can definitely follow up and give you more information about your specific state. But we definitely want to see you follow these steps. It's the same because IDEA covers federal law. So you'll hear me talk a lot about Texas, but just know it's pretty much similar across the board. There are a few states that stand out that might have differences in timelines. Those states being California, New York, and Florida are the three that I can mostly think of that are pretty unique in timelines, but the most of the other states follow the same. So here we are. You write a complaint from the state website. You can use their form, or you can write a complaint in your own words or knowledge. It's up to you how you would like to file the complaint. But after you've submitted the complaint, an acknowledged letter from the state will be sent to you confirming that they received the complaint, and then an investigation will begin. Okay, so know that once the investigation starts, it opens up a legal procedure, right? You're able to challenge the school's policies, procedures, the things that they are doing or not doing, whatever your allegation alleges. And because it is federal law, know that, again, it's going to be the same in all states. And if they are found guilty, it can open you up to a civil lawsuit action, especially if the damage continue over a period of time or there was harm. You can prove that there was harm done. But this is the first step. And so once you receive that acknowledgement letter, I'll give you a clue on what happens in the back end in the district. The district also receives the letter identifying the complainant. And if the complainant is not anonymous, you can make an anonymous report. It's just harder to follow up on anonymous reports to find out what corrective action, if any, would be implemented. But the district receives a notice as well, and they understand the allegations, and they will have to respond, right, to whatever the allegations are. Majority of the areas for review would be evaluation process, sometimes the identification area. And this is where I say I'm putting the cart before the horse, because in the SPED overview, I'll go over the 13 different categories that your child could qualify for services. Another area for complaints that's typically found would be uh, failure to follow or implement the IEP, which is the individual education plan. Educational placement would be another strong suit. We have those subcategories of least restrictive environment. You see this a lot for students who have discipline and behavior issues. Oftentimes they're referred to behavioral placements, and it's almost like a jail sentence. It is extremely hard to work your way back out if you don't have a parent that is advocating, if you have poor record keeping skills in the classroom. Get to know the paraprofessionals. If your child is in adaptive behavior program, we call them AB programs. Definitely, you want to get to know not only the teacher, but the paraprofessional. Their primary job is to track the points. And if there is a grievance or an issue with a paraprofessional, your child can literally get stuck in that program, and that's not the intention of the program, nor what we want for your child. So make sure that you are staying abreast and making sure they collect appropriate data. That data will be critical in submitting through the due process to prove your point and justification for educational placement. Sometimes you'll see TEA complaints for lack of services provided. The child may be ARDed for psychological services and or speech services, but the school doesn't have one assigned. So they'll fall behind on their speech hours. Districts often will offer compensatory time, but again, there's little oversight over the compensatory time. You as a parent would really have to do a lot of tracking to make sure you're getting the hours that are due to your child. And then the final area of complaints we often see would be the area of FAPE, and that's the free and appropriate public education, right? Every child is entitled to one. So this due process will ensure that parents and students have a voice in the special education decision process. If your voice isn't heard at the art table, this is the next step meant to protect your rights. Okay, so once you file the due process complaint, you will receive the letter indicating that they will start the review of jurisdiction, and that's just the review of the district. TEA will let you know that the filing is something that they have authority of. Again, personality issues, TEA isn't really going to do much about that. You can always file a grievance against the teacher if the teacher was unethical, but they're really looking at legal issues to hold on to. So again, those areas that I just reviewed to you, those legal violations of IDEA, Individuals with Disability Education Act, those are the things that they will move forward with and would meet the filing requirements. The district will have 10 days to respond to TEA, as I mentioned before, as the investigation continues. TEA will assign an investigator to review over information. In the meantime, 15 days, the district will invite you to a resolution meeting. Okay. And so in the resolution meeting, um, if you've actually filed due process and not just the complaint letter, the resolution will allow you to sit at the table again one final time. You have the option to involve a mediator if you like, but it's one final time to get things right. And then you can pull the complaint, right? Or you can pull the due process hearing and allow the district to agree with you or to provide the services that you're disputing about. If that doesn't happen, you hold the right to file your complaint again. So be very careful about that and considering dropping complaints. I've represented many parents who has went back to the table during the resolution process, and the district often promise you that they, will agree to offer transportation, agree to decrease, the least restrictive environment hours in general education. They make those promises, but then they don't follow through with them. And so, again, I really discourage parents from attending the informal meetings. Make sure you get everything in record uh, through deliberation page. Okay. If the dispute is not resolved, then we move on to the hearing process. A corrective action plan sometimes can be issued to the district. Sometimes it is for the entire district. Other times it would just be for the school to make the corrective actions and whatever they are that need to be made. Sometimes it's additional training for staff. Other times it may be changes in the way restraints are made and additional training for staff, perhaps a difference in documentation or collection of accommodation logs, updated IEPs, whatever the allegation was, the corrective action plan will fit that. Now, both sides will get to present evidence if it moves on to due process, and the hearing officer is the one who would make a written decision. Now, that's beyond the complaint process, that's the actual due process. That hearing officer, usually will administer their decision within 45 days of the actual hearing date. And again, the hearing will come if, the resolution was not successful, if you weren't able to agree at a resolution meeting. Either side can appeal the decision. So the state can appeal, the district can appeal, and you as a parent can also appeal if you don't agree with the hearing officer's decision. So you have a right, you need to know, to review all educational records. You have a right to have an attorney present or an advocate present. Another thing that I often hear, somewhere here in between the investigation process and notifying the district usually ramps up and demands that you attend a resolution meeting before the hearing date setting, because sometimes they do want to resolve. They don't want these complaints in the court system, and they don't want another corrective action plan filed against their district. So I'm not sure, my audience, if you guys would like to drop in the comments what function and role you serve in. I'll take a moment to stop and look at the comments to answer any questions you may have. But if you are representing the district, you want to stay out of due process. You don't want to get involved there if you don't have to. Don't stay there, because due process can be very stressful. And again, if the district finds you at fault, your name goes into that complaint, and the complaint is public records. So your name will be filed in the public. So be careful of your decisions, how you document, how you update IEPs. Make sure you become familiar. Not only parents, but teachers become familiar with the procedural safeguards so that you won't get stuck in a situation depending on the experts, which would be your special ed staff and administrator, and participating in an illegal ARD. Sometimes we call them drive-by ARDs, where we're not actually sitting at a table discussing the child, making a decision. We are actually making decisions via emails or texts without parent input. So we really want to avoid that. That is illegal. If you're forced to participate in a situation like that, you really want to make sure the parent has given you permission to move on um, before you participate in something like that, because, yeah, it's just illegal. It's unethical as well. So we talked about the filing complaint. I mentioned the corrective action that goes out. Special education in Texas, this is for Texas, has a special education monitoring cycle. Every 4 years, they go into district to see what's going on. They're looking at all of the indicators. And last time I checked, I think there were 19, might be 21 indicators, but they're looking at each one of those indicators. They're going through the educational file records. They're going through the SPED file records. They're looking at every ARD. If the kid is 14 and over, they're making sure the ARDs are addressing transition services, secondary transition services. They're making sure that there's someone invited from the community, such as someone from Texas Rehabilitation Services. In other states, I'm not sure what social services you might have, but there is a workforce commission in each state that works with individuals that have disabilities to help employ and train them. So every 4 years, those monitoring cycles happen. Now, it can happen more often based on the number of corrective action plans the state or district receives. So this goes back to me mentioning the districts really don't want us to move forward in the complaint process. It really is in their best interest to try to come to the R table IEP meeting and make a decision that is in the child's best educational interest, right? And what the law requires. Sometimes we can go above and beyond, but at the minimum, we need to do what the law requires. Here are some other states I mentioned I knew that had marked differences. California also has a 3 to 4 year range. That 3 to 4 years is going to depend on the notices, referrals that they're receiving. If they have a high number of complaints for a least restrictive environment, they may trigger them to go in a little more often. Florida, however, and New York extend their timeline out to 5 years. If there's not any issues or any complaints going on, they're only doing their general monitoring every 5 years in Florida and New York. So, with that being said, you can do research to see where the referral rate goes with the lack of monitoring. So, at Ahava, we do have monitoring plans. We do educate our parents. I'm always encouraging you to ask for the accommodation logs. Don't take for granted that it's happening. I just sat in the ARD Thursday this past week, and a student received 100 in English, 100 in language arts, 100 in PE, 100 in science, and a 50 in social studies. Guess which teacher did not show up to the meeting? The teacher that gave her a 50. And I said gave because as an advocate and as a former certified teacher, anytime I see round numbers, 80, 90, 60, 70, I'm going to question that that's a true average. What are the chances that your child average really came out to that nice, beautiful round number? Those are generally times where teachers are making up grades. I'm just going to be honest with you. I've been in the ranks, as I mentioned. I've seen it as a former educator myself, as a former principal, and collecting and reviewing grades. It happens. It happens. So you have to make sure that you are asking questions. The teacher that gave the student a 50, I requested that they come to the meeting. When they came to the meeting, my very first question was, Are you aware of the student's IEP? Yes, I'm aware. Yes, absolutely. I'm aware. Okay, awesome. Can you tell me what accommodation she has for social studies? There were crickets, silence. She could not answer because she did not know. So, as parents, I'll give you another little tidbit. At the beginning of every semester, I would ask for um, teacher signature receipts. Teachers are required by law to sign IEPs once they're updated annually for students that are in their class. If they have a BIP or behavior intervention plan, that should be given to every teacher that services a student, along with the administrators and nurse, and they should be signing for it. We take for granted that that's happening, but sometimes as parents, you have to advocate, you have to ask those questions. Once the school knows that you're going to ask those questions, once the school knows you're requesting logs, you're monitoring, they're more likely to do the right thing by your child. They're more likely to do the right thing. So make sure you are active by asking those questions. If you haven't already, I do humbly request that you follow our YouTube channel. We have updates often, usually every week. Right now, you'll look through our podcast. We have updates regarding transportation as a related service and making sure you know where it should be documented in the ARD. So if you haven't already, I really would like to have you join us at Ahava Learning. If you haven't already, visit our website. Please also take the time to visit our website, ahavalearning.info. There you'll find free downloadables. After this live, I will update a couple of free downloadables. The TEA complaint process, for those of you in Texas, will be uploaded so you can have an idea of what to expect if you're going through that process. If you need help, please reach out. Remember, our advocates are certified and experienced. We get results. Okay, we get results. So we'll move on to the second part. I don't see any questions or comments. I don't know if I'm overlooking them. I hope not. Yeah, I don't see any comments. Okay, so we're going to move forward with the second part, knowing your rights and how to advocate. And as I mentioned, I kind of put the cart before the horse because the first part to me is a little, talking about the legal law, it's kind of boring unless you're in need of it. If you're in need of it, you're going to definitely be interested. That's really good information that I gave you. So you'll know what to expect along the way and make sure everyone's meeting those timelines. So take that for what it is. Now let's do an overview, a SPED. Some of this information you may know, some you may not, but as I'm going through it, I will definitely make sure that I am able to update you guys as we go along for any changes. So starting off, our goal here is to provide information regarding IDEA and the Rehabilitation Act of 504. So those two groups of students will be protected. These are federal laws that protect our students throughout their educational process. It changes a little before, from birth to 3, and then our early intervention years. There's some different interventions that we do there as opposed to grade school and beyond. And then post-secondary, that's really where the Rehabilitation Act and 504 services will really kick in making sure students have accommodations post-secondary as well. We'll get an opportunity, if time permits, to review the TEA complaint form, and then I will stop sharing and take some questions from you all. Okay. For fair selection, I just got a someone just texted me and told me they're not able to make comments. It's something I have to change. Let me see if I can go through and make that change. Let's see, comments. I don't know how I turned them off. I don't. Oh, I do see that. It's grayed out though. It won't let me change it from off to on. I don't know how to turn the comments on. I'm sorry. I am definitely sorry that I wasn't able to turn the comments on. But after this is over, I will post it, and you guys can leave your comments at the bottom, and I'll come back and check them. You can also send us an email at ahavalearning.info if you would like to schedule a free consultation. Now, we'll move forward. For fair selection, everybody has to take the same exam. Please climb that tree. This is what Professor Ingleberry is telling all of these little individuals here. I see a crow, I see a monkey, a penguin. Imagine an elephant climbing that tree. How the poor fish in a fishbowl, how will it ever make it to the tree, let alone climb the tree? It's in a fishbowl, right? So this is what we talk about when we look at special education services. There are SPED services. We cannot teach everyone the same. We cannot expect everyone to learn the same. We don't all have the same skills, qualities, or equipment. So it would be unfair to expect us all to learn the same. And so I thought this was a beautiful illustration of us, especially if you're a teacher, to be cognizant of what it is that we're asking our students to do. As a parent, think about, your own capabilities and what it is that you're able to do, and what is more difficult for you to do. And you'll understand that it may be difficult if you don't have hands and feet to climb a tree, right? It's not that you don't want to. It's not that you're being oppositionally defiant because you can't get up the tree, right? It's just that you're a fish and you live in a fishbowl. You have fins, right? You can live underwater. That elephant could never live underwater. It might be able to walk through the water, but it will never live underwater, breathe water, and stay alive. It will drown, right? So we each have our unique challenges and differences. So wanted to add that to the session. Now let's go over the law. I mentioned Section 504. There are some that are not serviced in special education. Can an advocate still represent you if your child has a 504 plan? Absolutely. 504 prohibits discrimination based on disability. It covers programs and activities that receive federal funding. That would include most public and charter schools. Some private schools do accept federal funding, and they would have to comply with this law if they receive federal funding as well. The idea is that it will protect a student who has a physical and or mental impairment, which substantially limits one or more major lifestyles. And I really need to update this to say not only physically or mentally, but health would be included. I guess that's physical, but there could be health issues as well. The criteria here is that the life activities are daily activities that are impacted, such as eating, sleeping, walking, transferring, ambulatory around the campus. A student may qualify for 504 services. That includes learning, concentrating, thinking, and or communicating. So just because a kid has a disability does not mean they have to be serviced under special education. When we talk about the least restrictive environment, and you're going to see a diagram in just a little bit, you'll see that Section 504 would be your least restrictive environment. Typically, these students are serviced in the general ed setting, not a SPED setting. Um, their curriculum is not modified. There may be accommodations provided, again, but the curriculum is not modified. We're not expecting them to learn something different. It's a myth that 504 students are in SPED. It's a completely different area of service. This is the SPED babies. They're covered under IDEA, Individuals with Disability Education Act. What is it? What does it cover? Let's get into the meat and potatoes. Here's the federal codes. As I mentioned, there are 13 disability categories that a student can qualify in. These are they. Now, if the student has one of these disabilities, you can request in writing that your school tests your child to determine if there is an educational need for services, individualized services. They may actually have autism, but they may not have an educational need for special ed services. Perhaps they did early intervention, they've already addressed speech and pragmatic skills, there are no learning issues or behavioral issues, they're functioning on grade level. It's amazing. Pardon me. Pardon me, if you have a dog, you understand the interruption. So let me go back and review the previous screen. Again, there are 13 areas that a student may qualify for. And again, there has to be an educational need. The disability alone does not indicate that they would qualify for special education. Again, you want to become familiar with procedural safeguards. It will tell you the criteria for students to qualify. These are the 13 areas. This area here, non-categorical early childhood, and a long time ago used to be called PPCD. I think it was the primary school for PPCD. I don't remember what the acronym was, but the acronym, this is new, but it replaces the early childhood label when kids are too young to identify them as with a specific learning disability or to say for sure that they're on the spectrum. They would often get this category diagnosis by the age of 3 or 4. Um, by first grade, we're able to better determine specifically where the disability might arise. Another one I'd like to point out to you is the other health impairment. We see that one frequently for students who have ADHD, the attention deficit hyperactive disorder. Sometimes it's combined type, but that's an area that can be serviced under special ed and or 504. It really depends on if the curriculum is needed to be modified. Modifications cannot happen in the general ed setting or 504. Modifications can only happen in SPED. I think all the rest of them are pretty self-explanatory. If I can highlight specific learning disability, dyslexia is now included in this category. That's something that has changed in the recent years. I think the last 2 years. Before dyslexia was serviced in 504, under 504, but now it is a part of a specific learning disability. And an evaluation can determine what type of dyslexia and the areas that it impacts the educational needs. So it would be a good referral if you suspected dyslexia. That would be the area that they would qualify under. Now, if they have multiple disabilities, that's going to be multiple health issues, multiple diagnosis. Will sometimes get the MD category, but I don't see that used very often. Usually we just list them separately. All right. I do have links here available. If you would like a copy of today's presentation, just email me. I'll put my information up in just a second so you can have it. You can definitely go to the website and get my email from there. But I'll definitely share my slides with you. Our goal here at Ahava Learning is to make sure that parents are educated, teachers are educated, and the district as well, and really bridge the gap. We're not against the district. Again, we used to work in the district, so we do understand that teachers are working extremely hard, especially in the area of special education. Oftentimes, teachers are abused, hurt, and overwhelmed with everything that's going on. So it's just that the turnover rate is high. So if you do have a special needs student, please show your appreciation to their teachers, especially if you're in Houston Independent School District. You have to know that the stress that they're facing is it's an enormous amount of stress, and they really want to do the best that they can. But sometimes they're literally limited just because of resources. So don't take it personal as a parent when you find that there are failures in following your child's IEP. Sometimes it is simply because there are not resources available. And so again, if you think back to the TEA complaint process that I showed, once the district responds to TEA, they can honestly say in their TEA, and again, this is my principal hat, they can respond to TEA and say, yeah, we did not provide one-on-one aid to Johnny because our school is short 6 aides. And then they can show proof that they have 6 vacant spots for aides at the campus. They can show proof that they've tried to apply or hire the 6 vacant spots, right? So if they show enough evidence and proof that they've tried to fill those positions, but they can't find a qualified individual to work in those positions, they can't provide a service for you that they don't have. Not that they are denying the service, they don't have the people. So then we look at compensatory time, then we look at hiring outside help, then we look at, other things, perhaps bringing in a consultation or a dedicated sub that we train in SPED and restraint processes and things like that. So that's an art committee decision and determination. I would not automatically say take it off the table. I would still ask for what your child needs, but understand there may be limited resources, literally limited resources. And I also want to take the time to make sure you're appreciating the professionals that stay in the field. You guys, if you look on TikTok, you scroll through social media, you'll hear the teacher exhaustion. You hear the teachers overload. Teachers really want to just teach. They do. They do, but sometimes it can become difficult. So I'll get off my little side soapbox, but I have to, represent for the teachers too. I don't want you guys to think that, the IEP advocate is upset with you all. I'm not. We're on the same team. All right. So the main components of the IDEA, I kind of briefly mentioned them before, but you want to definitely become familiar with your procedural safeguards. There are many components in there, timelines, what you should get a copy of, what should be documented, where it should be documented. I know you get it almost every meeting, definitely with every evaluation. Many people, I cannot tell you, do not take the time to read through, what is it, 72, 42 pages. I don't even know how many pages there are, because it's updated often. But if you've ever received an email from Ahava, you received a copy of your procedural safeguards. If you're in Texas, you've also received a copy of our ARD guide. And make sure you look at those two documents because it goes over all of these components. We talk about free and appropriate public education in the ARD guide, the least restrictive environment, and where is that? And does it mean? Does the least restrictive environment always start in general ed? No, not necessarily. It can start in other areas based on what the child's need is. But once you identify their least restrictive environment, it can change. And that's why we do assess our students annually to see if there are changes that might need to take place. This becomes a big deal for those behavior kids. Again, once they're placed in those adaptive behavior classes, it's really, really hard to earn the points to transfer back out of those classes. What's even harder is to go to an alternative program or placement outside of the school, because many of those programs are organized where you're earning points, but if you have one bad day, you lose all your points for the week. It's like starting over. So imagine having a great week Monday through Thursday. Friday, you get a little excited during morning announcements, and the teacher writes you up. You mean to tell me I worked hard all week and I lose? That's enough to make anybody tear up a building, right? So, of course, that's going to set that kid off. So, just be careful and aware of those procedures. Ask questions, especially if you have an alternative placement, and consider the least restrictive environment. Make sure the data and the evaluation matches all of this, right? Because evaluation is going to tell you what the disability is in. It's going to give you recommendations on how to address the disability and what changes to make. Okay, so definitely pay attention to it. This is a quick YouTube reference video. Now that I've created this one, I might update it with our leak. Let's do a quick overview for procedural safeguards. Procedural safeguards is a document. It must be given at least once a year. It definitely has to be given with evaluations, right? It should be given to the parent in their native language. The document should be interpreted into your native language. And this really becomes an issue. I'm working with a family now that I serve that speaks Farsi. And it was hard for me to find a Farsi document in the procedural safeguards, just because it's not a common language. You can find Spanish. I think you can find a couple of French. I've seen it in Vietnamese, Mandarin, maybe, I think is what it's called. I've seen it in a couple of languages. So go to your state website, search for procedural safeguards, and then you can also look to change the language. If you don't find your language there, I'm speaking this as if you can understand English, but if you're concerned and you're looking for a particular language for another family, you can always go to the website and search directly on the state website, and or call your state SPED office, and they can provide you the document in the native language. But that's critical. That's important. Do you know I have won cases, not necessarily won cases, but found districts have been given corrective action because they failed to give parents the procedural safeguards in their native language. They automatically gave this parent an English procedural safeguard. That little technicality. And then when you start having a lot of little technicalities, these are the things you want to document to help include in your complaint to the state. Because what it shows us, it shows that the school is not professional and they're not keeping accurate records, right? They're not considering the home language survey. Had they considered the home language survey, which is a part of reviewing the student's file, they would have noticed the native language would have been something different. So those little technicalities, having the experience to know to look for them, can help build your case in due process. This part, coming up next, a prior written notice, you'll often hear it referred to as PWN, is extremely important. The schools must give you a PWN at least 5 days prior to proposing or denying any action. They can always be amended, but anytime you ask for something in writing from the school, if they deny it, you want to have them documented on a prior written notice. This is documentation that you also take with you to due process. Teachers, if a parent asks you for something, don't just say no because you feel like saying no. We really want to, if we need to come back to the table as an art committee and consider that student's needs, consider that parent's request, use data to make your decisions. Parents, use data to make your requests, and then document the denial of the action that was proposed. That's critical. You'll need to have that documentation when you go to court. All right. Also know that as a parent, you have a right to request an independent educational evaluation if you feel that you disagree with the schools. There are some conditions here. The evaluator must meet the school district's criteria and conditions. They have to be certified and licensed in the area that they're evaluating. Some districts will require that they have a current contract with them. I have argued against that. If you have an evaluator that does not have an active contract with the district, we would just need to find out the process to request for a contract, because you can name the independent evaluator that you like to have provided. Now, if an evaluation was recently done and you disagree, there is your right for an IEE. Now, if there's been time, there hasn't been a recent evaluation, let's say it's been 18 months. Because it's been less than 2 years, technically the school district can deny your request for an IEE. Had it been at the 24 mark, 2 years, the school district would have to honor your request for an IEE. Any evaluation done within the last 2 years, they do not have to honor it unless there is a need. So as a parent, again, this is where you build your documentation. Why are you requesting another evaluation? We reviewed the old evaluation. We reviewed the IEP. The IEP was updated. The goals are mastered. The student is receiving 100s. It's time to create a more rigorous plan for her. And in order to create a more rigorous plan, we'll like new testing information, new testing data. It seems like she's made great improvements. And you'll be surprised. We've actually dismissed some students from special ed for this very reason. Literally, the kid behavior increased. His grades were awesome. He was so freaking smart. Before you can ask a question, he was answering it correctly. He was brilliant and bored. And so his mom requested an individual evaluation. And we also requested for him to be tested for gifted and talented. And he, I don't remember if he qualified or not, but that's your option. You have that option to do that. Those are the conditions in which the school may deny it. But again, have them document that on a PWN. Manifestation Determination Review Meeting. Not sure if you understand or know what that is, but okay, this is where your kid has been accused of violating the student code of conduct. Certain violations above 3. If you look on the student code of conduct in any school district, there are levels. Level 3s and above typically automatically triggers an MDR. Violations of code of conducts, level 1s and 2s, may not necessarily trigger an MDR, is what we call manifestation determination review meetings. And the reason being is because level 1 and level 2 offenses are usually minor offenses: excessive talking in class, failure to follow directive. Those are like small level offenses, something you can assign in school suspension for. You can call the parent, you can implement other discipline actions. Level 3, level 4, we're looking at changes of placement. We're looking to determine in the MDR if the student's disability directly impacted whatever the behavior was, whatever the action was, right? Johnny punched Rhea in the face. Okay, we have to find out, what is Johnny's disability? If Johnny's disability is other health impairment, ADHD, right? Hyperactivity, impulse control, there might be a connection. And I'm going to tell you, as a diagnostician, the average school will say, no, there's not a connection. This is where you would need an advocate to go in and really comb through that evaluation. And let's look at this kid's executive functioning skills. Let's look at their impulse control. Let's look at their hyperactivity. You can go to the doctor and ask your doctor to help write a statement that, this behavior. Again, this is why you don't want the school to pressure you into demanding that you show up for a meeting within a record amount of time. They have to give you time to prepare a case, to review data. This is how you collect data. That data should be, you should enter the MDR with that data, not with the hopes of getting the data and coming back and talking about it later. Because I'm just going to be honest with you. From the school side, teachers, y'all know I'm telling the truth. They've already made a decision before you walked in the room. So you really have to go in a room armed with data to make them change their mind, right? To show them how that behavior, action was directly tied to your child's disability. And then if it was not, it was not. He's going to be disciplined. He or she would be disciplined like any other student without a disability. So look at that. Again, the kid that has a specific learning disability and he punches someone in the face. No, that's not going to be tied to the disability, right? But those, even I can think of some autistic students might do that if they have a fight or flight issue, or there's a loud noise that startles them. They may act out, stimming. They may act out or touch someone inappropriately. That has happened before as well. And for a student without a disability, inappropriate touching or groping would be an automatic placement, either 30-day or 60-day placement. The committee can determine that. But for a student that is autistic, that may actually have a stimming issue with, touch and sensory issues, we might be able to say that it is directly related to the behavior. And in that case, that child would not be disciplined like others. Children with Tourette syndrome. When I was in high school, there was someone in our high school class that had Tourette's, and he would just scream FUCK out randomly. And of course, we all laughed at the beginning, but after a while, we just kind of got used to it because it was no longer funny. You knew that he had a disability and he couldn't help it. But he would tell you he was, extremely embarrassed by it. So MDRs can be very tricky. If you ever find yourself in an MDR as a parent, I encourage you not to go alone. If you cannot afford an advocate, I would recommend that you take your sister, your cousin, a neighbor you can trust, somebody else into the room with you and do your research before, making sure that you have the appropriate data to support what you're requesting. Okay. Elevating concerns again about the IEP facilitation, the implementation of the IEP, the state complaints, mediation, our due process. It's all going to be covered in the procedural safeguards. It'll tell you exactly what to expect. So take some time and read through that document. Now let's talk about the least restrictive environment. We mentioned that before. The least restrictive environment is going to be a continuum of service. It's going to be closest to the general ed as possible. When you think about special ed, you may think of, the classrooms being, all in the back of the school or in the outside temporary buildings, right? But our classes are really integrated throughout most campuses. Very seldom will you see, and actually I think it's illegal, which is the reason you don't see all SPED grouped together. The children have access to the entire building, and hopefully they're able to navigate safely throughout. If not, then we should request an OT eval to help them navigate safely throughout. But when you think of it, know that it's a continuum of service. There are non-public placements as well, and outside placements outside of the district. So it goes from a wide of services, like I mentioned, from general ed to 504 to SPED in the general ed with accommodations. Like it goes all over. We're going to look more into it. Hold on just a second. And then also there are opportunities, pardon me, going a little too fast. How did I get there? Sorry, you guys. It's hard sharing my screen. I can't see. Okay. Also, with the least restrictive environment, every student, no matter their placement, should have the opportunity to attend their electives, right? Those that are in adaptive behavior class, you want to make sure they have a plan to transition or reintegrate back into the school environment. How do they do that? Maybe they'll go out for one class for resource, right? Maybe they'll do reading and resource instead of the behavioral class. And as long as they don't have any incidents or no behavior issues in the reading resource class for one class, maybe they'll go out for a second class, maybe reading and math in a resource. No issues, no problems. Okay, great. How about now we take one class out in general ed outside of your electives, outside of your specials? How about we do a science in general ed, right? So this is that reintegration plan to get them back into the least restrictive environment. So please know that is possible and that there are continuum of services that you can access. So this is what they look like. My mouse is so sensitive. Here they are. We have general education all the way over here on the far left, right? With no supplementary aids or services. This kid, we just know they got, some special needs, maybe special transportation, right? It might be orthopedically impaired. There's nothing wrong with them cognitively. They don't need any other aids or services other than transportation, right? Here, transportation can be listed as a related service, and that student's IEP. I could think of a student like with multiple sclerosis, right? Or scoliosis, something that would prevent their movement. And it could be service under 504, but 504 doesn't offer the related service of transportation. And so that's where we would pull the kid into SPED and offer that, but they would go to general ed for everything else. The next step would be general ed with supplementary aids and services. Here you'll have accommodations. Here you'll see 504 student service in this particular environment in a general ed classroom taught by a general ed teacher with supplementary aids. That's just a piece of paper telling the teacher, this is what we want Johnny to learn, right? And this is what you have to help him do to learn it, right? Um, that's it. You might get a special ed teacher that come by and check on Johnny once a week. You have any questions, Miss Gray? How is Johnny doing? Is Johnny turning in his assignments? That's what you call a consultation, right? A consult. And it's documented that the student was serviced that week for 20 minutes when that adult probably never touched that student. So we want to really make sure parents looking at the schedule of service page, you want to look and see where your accommodations are taking place and who is responsible for implementing them. You want to know where the accommodations are taking place, which setting, if it's a general ed setting or a special ed setting, and who's responsible for implementing the accommodations. If it says SPED teacher only, but the SPED teacher only comes around for 20 minutes a week, how then will your child receive aids the other time? We have to consider that, right? We have to look at that and make sure that the aids are being implemented, or the accommodations are being implemented throughout the day or in the areas that they're supposed to. The next setting would be that specialized setting. It could be the special ed setting with general ed. I'm thinking of resource, perhaps. Would be a pull-out program. There are some tier programs as well for response to intervention, but I'm thinking about SPED population in particular here would be a resource, right? They may go out for resource for reading and math and then go back to their general ed class for science and social studies. And of course, their elective and, PE and lunch, right? The majority of the day would be in gen ed. We just have some pull-out classes for SPED. Then you have those specialized settings where the student is more likely self-contained. Those would be maybe some life skill classes, those adaptive behavioral classes that I mentioned. That's where the majority of their day is spent in the SPED setting. Again, parents, you can find this information on the schedule of service page. It'll tell you the area that the student is being serviced. It'll tell you who's responsible for grading that student, and it'll also tell you who's responsible for implementing the accommodations. In cases, what you'll like to see is both. You want to make sure that that general ed teacher knows how to implement that accommodation, just like the SPED teacher. If the SPED teacher is not around, that gen ed teacher can still go forward with implementing that accommodation. Now we give it to them, but do we actually show them how to use it? Do we show them examples? I'll be honest with you. I used to be a principal. I planned professional developments. General ed teachers get minimum exposure to SPED services, very minimum. And so sometimes they really don't know how to implement the accommodation, and they're too embarrassed or ashamed to acknowledge it. They think, "Oh, I can get around with it. Don't worry about it. I'm not going to fail him." That's where you get 70s. Do anything except fail them. 70. Question it. Ask questions. Ask for the accommodation logs. That's a good sign that they're not making them. And what that hurts is it hurts your child because it robs them of the opportunity of making progress and learning, right? It keeps them stagnant. And what's really critical is that a certain age, right about when they're hitting puberty, is when they will give up and lose interest in education. So it's very critical that we respond appropriately in these early years, because we can make a difference in how the child sees education, how they see reading, how they see math, how they approach these subjects that they find difficult, the way we respond to them as teachers, the way we respond to them as parents. Their hearts are fragile. They are very, very fragile. And understanding that they are different. Approaching puberty can be very, very difficult for these boys and girls. Remember that and consider that If you're a teacher, let's talk and reason with them more, okay? And then finally, the most restrictive environment will be a separate facility where they're spending 100% of the day in a sped environment. This can be a separate public setting or a private residential setting. So if your child could be expelled from the district AB program and sent to an alternative placement that's outside of the district, but they are only going there throughout the school day from 8 to 4, right? That's a separate public setting, but it's 100% sped, right? It's a separate setting, 100% in the facility, right? And then there are the residential facilities. Here, I can think of those that are in hospitals settings, pardon me, either for mental health or other health conditions. They may qualify for those private settings. Those students that are adjudicated, right, that are in custody after committing a crime, they would be considered a separate residential facility if they are sped. All right, that's the least restrictive environment. Let's move on to evaluations. A lot of parents have questions about evaluations. This is covered under IDEA. It's also covered in your procedural safeguards. Schools are required every 3 years to do an evaluation to determine if there's still an educational need. Outside of the initial referral and the initial evaluation, every 3 years, your child will be formally evaluated. Now, the district can determine not to formally evaluate your child and instead do what's called a READ, REED. A READ is a review of existing evaluation data. A READ is a review of existing evaluation data. That's where they're looking at the old evaluation. They're looking at the data over the last 3 years, report cards, progress reports, behavior referrals, health referrals, counseling logs, speech progress reports. They're looking at all the data to determine, does this kid still have an educational need? So go back to the kid that I mentioned earlier, 100, 100, 100, 100, 100. When you see that, you think, wow, this kid is doing pretty good. He no longer has an educational need. But this is where we really need to stop and look at the IEP and if it's been implemented with fidelity, if it's actually been followed. Parents can request an evaluation at any time if new concerns arise. Again, you just need to have your data with you to back up that request. I want to also mention that independent evaluations at the public expense. Remember, I briefly told you earlier, if it has been less than 2 years, if it's in between the 2 and 3 year mark, they'll go ahead and test them. But if it's been less than 2 years, they can refuse an IEE. The district may refuse an IEE if you don't have the data to support it. All right, now FAPE, the free and appropriate public education. This is a critical one. Every district, every school must provide special education services that meets the need of your child, what they might need, right? Whatever their challenges might be. And that includes related services, as I mentioned earlier. So if the district assigns your kid to an alternative placement and they tell you, well, yeah, she can go to that school, but we're not going to take her. We won't provide transportation. Well, they've denied your child by denying transportation to the school that has the program that the child needs. They've denied FAPE by denying transportation there, right? Especially if it's not near the family's home. The district is required to provide the transportation. So as a parent, you want to make sure transportation is always listed as a related service. Make sure it's listed as a related service. Make sure you hear them read that in the deliberations, because sometimes they'll get funny. They won't mark it under related services. And again, some districts don't show you the paperwork. It's not cast, to the screen or into a public place where you can see it. So I just want to give you these little tidbits as we go along. I hope that you're taking notes and making sure that transportation is always listed as a related services to ensure you won't have an interruption of faith. All right. Those services should be provided free to you at no cost. I had a parent out of Brenham whose kid was shipped to Houston. I think it was almost 90 minutes away. And every day this kid had to ride the bus. And eventually he ended up getting suspended from the bus. And this district wanted the mom to take him 90 minutes, 5 days a week to the alternative placement program. The parent could not afford the gas. She didn't have dependable transportation. So guess what? The kid sat at home because he no longer had access to public education. Transportation was taken away from him. You kicked him out of the local school. Needless to say, you know how that due process went. So consider faith, and I'm just giving you the tidbit. Make sure transportation is listed as a related service. All right. Related services and supplements, they may be provided in any setting. Here are examples of others. You'll notice the last one on the list is a dedicated para. That's a one-on-one aid. You often see parents request that, and schools will often negotiate down to a pair during transition, right? That sometimes happens, sometimes it does not happen. So just be careful if you agree to go down to a pair during transition periods only. What you'll find with pairs during transition is it kind of it makes the kids stand out, right? So kids would want to walk away from the pair because they don't want to be seen in the hallway, especially in high school with the pair. So they would try to walk ahead of them, or they may refuse to go to the class because they don't want to be seen with the pair. So it could work both ways. Just have that discussion during the meeting, but just know if you do ask for a one-on-one aid and there's not one available, have it documented in a prior written notice as to the reason why, especially if you have data showing. One of the places you can collect data to support any of these related services and supplements would be the evaluation. Go back and look and see, what did the speech therapist recommend? What did the occupational therapist recommend? Look for those recommendations. Make sure they are embedded in your child's IEP. This is how you advocate. This is how you get the best, the most, not the less. All right. All right. So another thing, let me mention this before I move on. Speech and language services. I encourage parents to be very critical of those IEPs. Be critical of all the IEPs, but a speech and language IEP is crucial because you want the child to eventually start to make progress. Again, we don't want them in middle school and high school still in speech services unless they absolutely need it. But early intervention is key. It's critical. Not only that, but speech and language is how we communicate. It's how we access the world. And so if you have difficulty accessing the world, if you have difficulty communicating, requesting what you want or need, expressing what you want or need, or understanding what others are asking of you, it may come across as a behavioral issue. We have many, many students who are labeled with behavioral issues, and it's not a behavioral issues. There are language delays, expressive language delays, sometimes caused by trauma. So that's a whole nother training, trauma-informed awareness. And once you recognize that, you'll see that behavior as a need, an unmet need. And so, again, when we look at behaviors, this is where you would request for a functional behavior assessment to find out the function of the behavior. And sometimes it may lead to a speech and language evaluation. Consider that before you consider the behavior. The schools will always try to draft it and frame it around behavior because they are responsible. They have a duty of care um, for other children's safety and responsibility. Safety, and so they have to make sure they're responsible to make sure your child doesn't hurt other children, right? That's the duty of care. So, in making sure that they don't do that, they have the responsibility to seek a speech and language evaluation to determine if that might be an unmet need. So, consider it, parents. If the school doesn't recommend it, you can ask for it. Okay, so what's next? Next, you request an IEP meeting. I recommend that you have a agenda ready for the IEP meeting. Trust me, they already have their agenda ready. And if you've attended an IEP meeting or ARD meeting lately, you know they rush through it. They read through it so fast. Even if they have the screen shared, perhaps you're on a virtual form or in person, they will put it on the computer, but they're not reading word from word what they're showing you on the computer. They've summarized facts and then it comes across as like Charlie Brown teacher, right? Womp, 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 womp. What was said? Do you agree? Yes. Yes, I agree. I'm not going to ask them to repeat all of that again, right? So then we start agreeing and saying yes to things that we don't understand or that we don't mean to agree to. If you need clarification, please don't hesitate to ask. It's okay. Ask questions. If you need them to slow down, ask them, please slow down. Can you show me where it will be listed on the IEP? You can ask those questions, but you need to write them down ahead of time because when you get in the meeting, sometimes there are several people talking. They have their agenda. You have your agenda. Another teacher may have their own independent agenda. So if you write down your goals and what it is that you want to know, what you would like to accomplish, or and changes you would like to see in the IEP, you would have a more productive and successful meeting. Request documents and do a file review. I encourage you to do that before the actual IEP meeting because you may have questions that you need to ask during that meeting that you want on the record, right? You may want changes made. Ask for your documents ahead of time. Ask for drafts of the IEP ahead of time. I'm going to give you a secret as a teacher. What that does is that forces me to really consider your child, right? I'm not going to cut and paste an IEP. I'm going to be more likely to sit down and actually draft it if I fill it out ahead of time. I'm not completing the IEP the morning of the ARD meeting. That's where you see the cut and paste mistakes with other children's names listed in the report or on the IEP. The same goal that they had in second grade is still listed for fourth grade. No, check them on that. Question that. I tell every parent, get a binder. Keep every piece of document that your child receives in that binder, divided by years. Each art that you have, the purpose of the art, document that, and reference check what you have compared to what the school have. I'm working with a family now where the school has behavior documented that the parent was never informed of. The school has restraints documented that the parent was never informed of, which is illegal, right? But she would have never known that had she not done a records request or a file review. Her child was non-auditory. She couldn't tell her that she had been restrained that day, right? So consider these things as a parent. This is how you be proactive and get the most out of your child's education plan. You can also request an IEP facilitator. Most districts have those. That would be a district representative. That should be a fair and impartial. I say impartial, meaning that they're not from the campus, they're still from the district, but you can have a district representative come And sometimes you might have an art that's run a little more professional. You may have access to immediate answers if there are questions about legitimacy of if something can be done or what the law requires you to do. It may be good to have one. There are also mediators through our state. TEA offers IEP court mediation, right? And so they can attend an art meeting with you. You would have to let them know ahead of time to request one. But those are all, pardon me, those are additional resources if you cannot afford an advocate or attorney. And then we talked about filing the TEA complaint because I told you I did things backwards. And unfortunately, I can't figure out how to get my comments up. But here's my email, ahavacare1@gmail.com. Phone number you see listed is my mobile number. I do accept texts. I work as early as 7 a.m. I leave the office at 6 p.m. I normally do not work on Saturdays, but this Saturday I wanted us to have this discussion and have this opportunity to know that we still have an opportunity to advocate, even through the government shutdown, the lack of oversight. We will have to see what's going to happen in the Office of Special Education, if it reopens or if the funding will be shipped to the states for oversight. And if that's the case, we definitely know that we have to pick up our advocacy. We have to pick up our requests. Parents, you have to know what to look for. Don't be intimidated in the meetings. Ask questions. And if you need help or support, give us a call. Website, Ahava Learning. Let's see, I'm going to put this back up. Make sure you have everything you need to get in touch with me. Our website, ahavalearning.info. Our phone number is 713-702-9188. And also accept text messages. If you have a quick question, we do offer free consultations, 1 hour consultation. And then we have packages. Our packages are listed online. If you have any special requests or special needs, please reach out to us. We can also create packages individualized for your child's needs. I really apologize. This could not have been more interactive. I really thought I had it set up differently. I want to thank you all for showing up and participating. And thank you for coming to our first series of empowerment. Still, we advocate. Our next series is scheduled for, oh my goodness, December. I'm going to start promoting it. Not December, I'm sorry, January. Oh goodness, I'm looking at a calendar. It will be January 17th. That's Martin Luther King holiday weekend, January 17th. And the topic would be special funds, school choice funds. So I will teach you as the parent how to apply for parent directed special education funds. That's up to $1,500 a month. I'm not a month, pardon me, a year for parents of students with special needs. And they can be spent on parent directed areas. So I'll show you how to get signed up for that, to get that money and help with advocacy and or tutoring services. The next topic we'll discuss also on January 17th would be the school choice funds. Parents will have an option to receive up to $11,000 to $39,000 a year to go towards their child's education. And we really need to examine that and look into it. We don't know how that's going to turn out. But again, it's expensive to educate a child with special needs. Obviously, the more related services they have, the more adaptive services that they need, the more costly their education becomes. So what does that mean for parents who have students with special needs? those individual funds? Would they be better directed in a private placement, or would you consider public placement still appropriate? So we'll talk about the difference in where you can apply the funds and how to apply for the funds in our next empowerment series, because we definitely believe justice for all students, and we want to make sure that parents are armed with information that they need. And at this point, we want to arm you with some cash too, because times are getting hard out there. And we want to make sure that if you or your child are entitled to funding or any particular resources, I like to make them available to you. And you, as a parent, can decide if you want to take advantage of it or not. If you have any other questions or you need help with anything, please know that we are here for you about to help empower you, to uplift you, and encourage you. My heart goes out to you. Thank you very much for joining. If you are a school district or a school district representative, a teacher, and you need more help or support in the classroom, I do offer one-on-one coaching to professionals as well. I've been in the game for nearly 27 years now. At the end of this year, it'll be 27 years that I've been in special education. As I mentioned, I've worked in several different positions throughout. And as you can see, I have several different certifications to go along with it. So I would love to be a resource or support to walk with you on your journey. If you're dedicated to our students, I'm dedicated to you. So if you need help, don't be ashamed to reach out and help. If you haven't already, please give the live a like. And if you haven't, please press that subscribe button, hit the bell to be updated for all notifications. I think that's what they say on YouTube. Y'all, I'm not a YouTuber. So I appreciate your patience. Sorry for the interruptions throughout the process. And I apologize. I'm not able to take your live questions. But again, if you leave comments, I will come back and provide answers. And if you call, I'll answer. All right. Ahava Learning.info. Thanks again for joining. Enjoy your Sabbath.